Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, a few days ago, we did this video right here. It was about a case that upheld the District of Columbia's magazine ban. At the time, we said this is a very, very dangerous opinion because, well, it's a line of reasoning that a lot of other courts could actually adopt and technically use effectively to those that are less than intellectually honest. I said I was going to do a follow-up video. It was going to be about the dissent, and that's the video we're doing here today. Because although that opinion in the matter of Hanson versus District of Columbia is very, very disturbing, there is a very, very simple way to deal with it. And the dissenting opinion got it exactly right. So today, let's spend a few minutes and let's talk about America's most dangerous ruling actually has a very simple solution. Hey man, what's going on?
What's up?
Dudes that are here to detail your car are here. They need the keys.
Oh.
All right, thanks, man. All right, guys, check it out. The keys to the McLaren are in here. Anyone gets into it, take it for a spin. Wait. What are you doing, man? No, that's not how this works. Okay, you guys give up?
I can't get it.
No clue.
See you guys later. StopBox. Protect your family while protecting your family.
Where's my car?
Okay, America, here's what we're talking about. We're talking about the case of Hanson versus District of Columbia. As we know, for the second time now, District of Columbia's magazine ban was upheld, this time by a vote of 2-1 in front of a 3-judge panel. Now, we went over the majority opinion in this video right here and said, listen, there is a really, really dangerous roadmap in there using Rahimi. I told you they would use Rahimi to basically escape everything. Now, if you recall, right about in the middle of the video, we got to the point where the court had found, in fact, that high-capacity magazines, or magazines that hold anything more than 10 rounds, are in fact in common use for many lawful purposes, including self-defense. And so that should in fact be the end of the inquiry, right? Now, if we go back in our time machine here to the summer of 2022, when Justice Thomas authored the majority opinion in the Bruin opinion, he said, hey, listen, this two-step interest balancing test, yeah, it's really cute, but it's one step too many, and developed a much more straightforward, simplistic equation that for whatever reason, lower courts now seem to struggle with even more so. Well, taking a playbook from old case law, what the court here did was go one step too far as well, because when they reached the conclusion that magazines, high-capacity magazines, extra-large capacity magazines, whatever they're calling it there in the District of Columbia, that when they reached the conclusion that they were in common use for lawful purposes, including self-defense, that was the end of the inquiry. And so the opinion, the majority opinion that was authored in this case probably could have been about 4 or 5 pages long. But instead, and this is what the minority opinion points out, the majority decided that even though they made the requisite finding, and that is the end of the inquiry, they decided, well, let's just keep going, because if we do, we might be able to find a way to uphold this law. In District of Columbia v. Heller, the Supreme Court held that the government cannot categorically ban an arm in common use for lawful purposes. Magazines holding more than 10 rounds of ammunition are arms in common use for lawful purposes. Therefore, the government cannot ban them. Because the only history that we have when it comes to outright bans on firearms, and this is the only historical inquiry that needs to be made, and candidly, the inquiry's already been made for us, okay? The only historical tradition we have of flat out banning an entire platform of weapon is if that weapon is both dangerous and unusual. And certainly nothing that is absolutely commonplace in the American marketplace can be deemed unusual. DC has offered no reason to doubt that throughout all of this history, no federal or state legislature enacted a blanket ban on a gun in common use for lawful purposes. Yes, there could be limits on who possesses a gun. Yes, there could be limits on where and how you carry a gun. And yes, there could be limits on owning and carrying unusual guns. But DC has failed to identify any categorical ban on a gun in common use for lawful purposes in the first century of our nation's history. Now, this is not a novel legal theory here. No, as a matter of fact, if we go back and we start tracing the very first significant Supreme Court cases that dealt with federal gun control legislation, we will see time and time and time again throughout all of these cases, the United States Supreme Court has held in a similar fashion. Take, for example, the Miller case. The Supreme Court has since read Miller to say only that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, explaining this time without the multiple negatives that Miller said the sorts of weapons protected were those in common use at the time. And that is the truth of the matter, and the test really is that simple. If that weapon is in common use for any lawful purpose, including self-defense, well, then it cannot be banned. Heller stood for the same proposition. Whereas the United States has a historical tradition of prohibiting the carrying of dangerous and unusual weapons, there is no historical tradition of banning arms in common use. So arms in common use are protected, and a complete prohibition of their use is invalid. But sometime around 2008, 2009, all of the lower courts essentially just decided to start thumbing their nose at the Supreme Court, thumbing their nose at the precedent such as what was laid out in Miller way back in the day, and McDonald, and more recently Heller. And then there were many Supreme Court justices, if you recall, that were kind of sounding the alarm bells that, hey, there is a mutiny when it comes to the Second Amendment. Consider the case of Friedman versus City of Highland Park. When the Supreme Court declined to accept review of that, what did Justice Thomas say there? Heller and McDonald do not allow categorical bans on firearms that millions of Americans commonly own for lawful purposes. And hey, listen, even the case that's being used like snake oil to try to get out from many, many otherwise effective constitutional arguments, you know what I'm talking about, Rahimi. Yeah, even Rahimi upholds the principle that arms which are in common use for lawful purposes, including self-defense, cannot be banned, period, end of story, full stop. In doing so, Rahimi carefully built on Heller, McDonald, and Bruin. It reiterated the history and tradition test already well established under Heller, McDonald, and Bruin, while also reaffirming their distinction between arms in common use versus dangerous and unusual weapons. And so, as Justice Walker, authoring his sole dissenting vote in this case, eloquently stated, where do all of these cases leave us? For starters, Heller's four holdings remain undisturbed. There is an individual, though not unlimited, right to possess and carry arms. Exceptions to that right depend on history and tradition. There is no history and tradition of banning arms in common use for lawful purposes. And the truth is that this should be welcome news to all the courts, because what they're saying here is, hey, listen, you don't have to go back and look at the history books. You don't have to go back and do your whole analysis on your own. No, we've already done the analysis for you. And the rule is very simple. As the minority opinion points out, none of those holdings should cause unusual difficulty for judges on the ground. For example, in cases about the banning of arms in common use, Heller and its progeny require no mad scramble for historical records because they have already done the work and provided the test that we must apply. And when we fail to apply their rule, the blame lies with us, not with them. So we only need to really be getting into history if we're talking about something outside the scope of banning arms, which are in common use for lawful purposes. So if we are talking about laws that restore firearms rights, if we're talking about laws that may strip an individual of rights, if we're talking about laws that may restrict the sales of guns or the location in which an individual can carry guns, yes, there is a need to go back and determine whether or not from a historical context we as a society have accepted those sorts of restrictions. But when it comes to bans, just outright bans on common platforms of firearms, the good news for all the lower courts, including the DC court here, is that all that work has been done for you already. And the bottom line is, unless the firearm is dangerous and unusual, it may not be banned. End of story. Okay, the case once again is Hanson versus District of Columbia. We'll link it up down below. The minority opinion starts on page 44. If you got any more questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there. You let us know. It's probably going to be better than any idea we come up with. If you want to subscribe to our monthly newsletter, the ability to do all of that is right down there in the description box. And then finally, and most importantly, America, let's remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.